And we're going to assemble from all around the world a round table, which of course we would love to do face-to-face in a room somewhere, and benefit from the interaction between human beings around the table, but we can't do that. So we're going to do it online. And we're going to have a session which seems to be central to the way courts have dealt with this problem in recent times, which is the relationship between climate litigation and the separation of powers, critical doctrine in most societies, certainly those that consider themselves to be in the sort of Western democratic model. But here we want to have a global perspective because we know it varies. The interpretation of the law varies from legal jurisdiction to legal jurisdiction, has a context, has a political and cultural context. And so we're going to go around. We've got a lot of speakers. We've got hardly any time. It'll feel a bit rushed, but these are wonderful people you'll want to listen to. And I'm going to start, if I may. There's no particular sense in this order other than I want to get variety. And so I'm going to ask, if that's all right, if Michael Gerrard starts us off. Andrew Sabin, Professor of Professional Practice and Director of the Sabin Center for Climate Change Law at Columbia Law School. You and your colleagues do wonderful work gathering in all the latest developments in the world of climate change law. And you come from a particular jurisdiction that has had cases already emphasizing separation of powers and sometimes quite a sharp distinction between the role of the judiciary and the political realm. And I really would like you to zoom in on the experience that you've had in the US on separation of powers and these difficult boundary lines between judicial oversight and judicial overreach. Let me start with you, Michael, please lead us off.
Thank you, James. It's a pleasure being with you virtually today. Separation of powers is a major problem in U.S. climate change litigation, both with respect to the role of the courts as opposed to the executive or Congress, and the role of executive agencies as opposed to Congress. In 2011, the Supreme Court issued a very important decision in a case called American Electric Power versus Connecticut, which was a lawsuit brought by several states against several electric power companies seeking an order that they reduce the emissions from their coal-fired power plants. A unanimous decision by the Supreme Court, written by Justice Ginsburg, held that the federal common law of nuisance, which is the chief theory under which the case was brought, was not available against greenhouse gas emissions because the Clean Air Act, a federal statute, gave the Environmental Protection Agency the job of regulating greenhouse gases. And so it was not for the federal courts to determine the appropriate level of emissions. The Supreme Court left open the question of whether state common law nuisance might be available against climate change. There are now about 20 cases pending, mostly brought by cities against fossil fuel companies that attempt to use state common law and related theories to get money damages for the impacts of climate change. Most of these cases have been held up over the issue of venue. Do they belong in federal court or state court? The defendant oil companies want to be in federal court because they think it's more likely that the American Electric Power case will lead to dismissal. The plaintiff cities want to be in state court, but that issue has been going around for years and it looks like it's going to continue. With respect to the separation of powers between agencies and courts, in 2014, the Supreme Court issued a decision in a case called Utility Air Regulatory Group against EPA, and the court found that EPA had gone too far in regulating certain aspects of greenhouse gas emissions because Congress had not clearly given them the authority to do some of the particular things that EPA was doing. In 2016, the Supreme Court stayed the application of the Clean Power Plan, which was a set of regulations adopted under President Obama to reduce the use of coal to generate electricity. And the Supreme Court didn't issue a detailed opinion, but it was likely because, again, the Clean Air Act was not specific enough to give EPA the authority to do some of the things it wanted to do. Of course, we have the famous Juliana case, which has already been referenced, with 21 young people seeking an order from the court that the federal government prepare and implement a plan to control climate change. The trial court was very sympathetic and set the case for trial, but the Ninth Circuit Court of Appeals agreed with the plaintiff's claims about the severity of climate change and the role of humans and the federal government in causing it. There was no dispute about the science, but the majority directed that the case be dismissed because it felt that it was not the job of the courts to make major decisions on climate change. That's the job of Congress and the president. That was a very explicit rejection of the judicial role based on the separation of powers. So far in the US, we've seen two judges, just two, say that the court should take action on climate change, even in the absence of statutory authorization. The trial court judge in Juliana and the one dissenting judge in the Ninth Circuit. But we've had numerous judges dismiss attempts to use the public trust doctrine and other non-statutory theories against climate change. We now have a Supreme Court with a 6-3 conservative majority, including 3 justices nominated by President Trump to lifetime terms. These conservative members of the court seem to be embracing a doctrine called non-delegation, the idea that Congress cannot delegate too much discretion to agencies and that Congress needs to be extremely specific. If that is firmly adopted by the US courts, it could become a real problem for the powers of EPA under current statutory authority. The US courts have been very active in enforcing the environmental laws that are on the statute books, and the courts are very active in striking down administrative actions that exceed an agency's statutory authority, or even more so if they were not adopted in accordance with the necessary administrative procedures. So during the Trump administration, the courts struck down numerous actions on environmental issues and others based on procedural violations. So the courts have been a very important guard against executive abuses. But unlike the Netherlands, for example, of course, the US is not a party to the European Convention on Human Rights, and the US has not ratified the American Convention on Human Rights. The US Constitution does not speak to a right to a clean environment, and the US courts have not interpreted such a right to be implied in the Constitution. There was an attempt to do that in Juliana, but it wasn't upheld by the Ninth Circuit. A few states do have in their state constitutions a right to a clean environment, and we're seeing some action there. So I'm not optimistic that we'll see more judicial activism on these issues in the US courts. I don't see signs or trends pointing in that direction. Generally, decisions from other countries don't have a lot of resonance with US judges, and there are right-wing politicians and right-wing media that attack US judges who even cite foreign decisions. All of this is in the shadow of a very conservative Supreme Court. Lawyers representing environmental groups want to stay as far away from the Supreme Court as they can. The Supreme Court did issue a very positive decision in 2007 in the Massachusetts versus EPA case, but that was a 5-4 decision, and the composition of the court has changed since then in a very unfavorable way. So I wish I could be more optimistic about the prospects in the US courts, but that's the way I see it.
Well, thank you very much. We have to confront the reality of the case law as it is. But thank you very much, Michael. I'll come back to some of those points later if we have time. But let me move now to France. Let me move to Corinne Lepage, who is a practitioner with her own law practice, but also former Minister of the Environment. And it's particularly good to be able to speak to her because, of course, it's a different legal system, a different role of the judge. And where there are cases recently that are really quite striking that I'd very much like Corinne to refer to, the Grand Cinq case, which she was involved with. And I'd particularly like you to examine the separation of powers issue in the light of that case, and in the light of your part in that case as a practitioner, and someone who's been on the other side as a minister. That would be very helpful. So Corinne, over to you, please. Oh, we can't hear.
Très mauvais. Très mauvais. Le son est dégueulasse.
She's still on mute. Shall I say something?
Yes.
Corinne, you're still on mute. Can you, the line's not that great. Can you go?
I was disconnected.
Bravo, bravo, bravo.
Sorry.
Go ahead.
Thank you. I answered the first question.
Yes, please.
Yes. It's a legal but also a political obligation for the state to act. The government will have to take new measures to fight climate change before March 2022, that is to say 1 month before the next presidential election. This clearly means that the climate issue will be at the core of the presidential debates. This obligation is all the more important as the European Union has equipped itself with the means to verify that the member states fulfill their obligations and that the Court of Justice has the means to sanction. It is also a political obligation insofar as the government wants to give itself a greener image. Moreover, the obligation is both political and economic. The entry into force of the European taxonomy and the implementation of sustainable investments rules implies that investment choices are changing. This, of course, also concerns the business world, and the Shell judgment in the Netherlands is very important in this respect. Finally, the Council of State is giving a signal to all French administrative courts to be much more rigorous on all decisions that will have to be taken and which are linked to climatic issues.
Oh, thank you very much, Corinne. Just one more follow-up question before we move to other panelists, because we're very, very tight for time. The particular role of the judge in the French legal system. It's interesting from an advocate in this part of the world, and that role may, just develop a bit more why that might be relevant to a separation of powers question.
Okay. In France, we have 2 degrees of jurisdiction: civil and private, and penal, and administrative. Is separate. And the decision of Grand Saint is a decision of Conseil d'État, is the most important degree of administrative court. The question of the separation of powers is not only for the France, because in all democratic countries of the world, the separation of powers is an essential element. In France, in fact, the Council of State, Conseil d'État, refused to exercise any control whatsoever that is related to the legislator, and refused, for example, to order the state to draft a law. It's impossible. I ask in Grand Saint case and I lose. Neither can he take the place of the government, but instead he can force it to apply the law, and that is what it has done in the Grand Saint case. I observe, moreover, that they went further than the Belgian Court of Wallonia, which refused to issue an order in the name of separation of powers. It is very important to maintain this balance to avoid the criticism of the government of judge that opponents of climate policy are increasingly inclined to put forward. Thank you.
Thank you very much, Corinne. Can you hear me? Okay, so now I'd like to literally cross the world to Africa and to get Elizabeth Watuti to speak to us.
Yes.
Elizabeth is a climate activist. She's founder and president of Green Generation Initiative. She has a very compelling story to tell, and I'd like Elizabeth to speak to us now, if that's all right.
Thank you so much. My name is Elizabeth Watuti, an environmentalist and climate activist from Kenya, the founder of Green Generation Initiative, and also the head of campaigns at Wangari Maathai Foundation, and also coordinating a coalition for the protection of urban green spaces here in Kenya. And for me, I have had so many instances where climate litigation has actually worked throughout my activism, and also instances where climate litigation has had various obstacles. And the really most important thing to emphasize on today is that activism and climate litigation definitely go hand in hand. And it's important to mention instances where communities have actually won cases against large companies in my country. And a very good example is a recent instance where the Kenyan court blocked East Africa's first coal plant from being built in Lamu. And this was after a lot of activism from communities. People were mobilizing, organizing, and they also proceeded to court to really make sure that this case was being heard, because this was a community that was being seen as powerless. But at the end of the day, by the fact that the court weighed in, this community was able to really see the fruits of the activism at the end of the day. And this is where the National Environment Tribunal revoked the license that had been granted to Amu Power Company to build the Lamu coal plant in the Kenyan coast. So to me, this was a win for public participation, and this was a huge role that the court really played to support this decolonized campaign. But at the end of the day, we've also had so many obstacles where climate litigation has had different challenges at the end of the day that have seen to it that some of the things that activists are trying to do are not still getting to where we want to see at the end of the day, and not being achieved. And I do believe that climate litigation is definitely achievable in Kenya, in Africa, and entirely in the world. But it's only that leaders tend to also negatively influence legal decisions, making the court systems not to seem working. And a good instance, I have been championing for the green spaces protection here in Nairobi. And we have this instance where we've been trying to protect urban green spaces and make sure that we are striking a balance between green spaces and development. And I remember one of the really most important thing that was done by this Daima coalition was to move to court and file a petition against the construction of one of the main expressways in Nairobi called the Nairobi Expressway that was going to really destroy a big portion of the green spaces in Nairobi, including one of the most iconic parks that's called Uhuru Park, which makes us all remember the late Professor Wangari Maathai, who really fought so hard for the environment and fought greatly for this space, and still remains a great source of inspiration to young people like me. And so this petition in court ended up getting a stop order for this expressway. And it was after a great push where we had a time where over 3,000 Kenyans stood up at Uhuru Park and said that we want this space protected, and we are not going to hive off any bit of this park to be able to construct a highway. We need the green spaces for the future. And at the end of the day, we had, of course, a stand from the government, and they were no longer going to hive off that part of Uhuru Park, but we needed legal support so that we will not have instances where in the next years, this park will still be hived off in other places in Nairobi. And so even after getting this stop order, we thought that everything was all done and we could now relax and be assured that our spaces have been protected. And so we continued with the activism, knowing that the case at the end of the day has protected the spaces. And we kept on doing more activism and educating people about the green spaces, including an instance where we joined hands on Valentine's Day to hang love hearts to trees that had been marked for felling in the city. And this was just to pass a message to our leaders and to everyone that we need these spaces protected. But to our surprise, after 2 weeks of doing that activity, we found all the trees that we had hung these love hearts to, they were all fell down, and the expressway was being constructed and moving really fast. And as we speak right now, they're almost completing the construction of this expressway, and the petition is still in court and not yet been heard. So it tells you that there's still so many challenges that are affecting the litigation when it comes to supporting activism and also climate litigation. And it all as well lies on the independence of the judiciary as well. But what we need to see is to see also courts standing up independently for what is right, despite the fact that some of the projects that we are trying to take a stand on are partly being done by the governments and the big corporations. So this is something that I really feel should continue really being emphasized on, that we need to really stand independently for the right things, even when the people who are the most powerful are the ones that are opposing these things. And also in the general sense, as a young activist, sometimes we really struggle a lot to find spaces and safe places to actually protest. We've had so many instances where we've tried to even oppose some of these projects that I've highlighted to you. And it has been challenging because there are instances where either placards get confiscated, instances where we get stopped or interrogated by the police, even when these protests are actually peaceful. So it tells you that the climate litigation bit and activism go hand in hand, and we cannot assume that any of them can be on its own. So it's a matter of making sure that we stand independently to even support activists out there and make sure that we are standing up for the right thing, because so many communities as well are getting frustrated when they move to courts in instances where public participation has been ignored, and they end up even losing their cases, or their stand on the court end up being in a way interfered with by the people who are in power. So these are some of the challenges that I would say are facing climate litigation in Africa, in Kenya. And I do believe it's possible, for courts to help us make corporations and governments move faster, even in lowering their carbon emissions. And we definitely all have a very huge role to play in making sure that we are supporting activists all around the world and also supporting climate litigation, because there are instances where it has worked, and in instances where it has not worked, we know what has gone wrong, and we definitely know what can be done to make things right.
Brilliant. Thank you very much. Good stories there. I hope we've captured them all, and we'll certainly circle back around to the lessons learned from that experience, including the bad experience of having judgments not properly implemented. Next, I've got Amy Rose, senior lawyer, Director of Litigation Compliance at ClientEarth, an organization that would understand very much Elizabeth's arguments. Over to you, Amy.
Well, I just, in light of the time, I wanted to talk about some of the separation of powers that we face. They actually come up quite regularly in our cases. And if you think about the separation of powers doctrine more broadly, not just at the powers between executive and legislative and judicial in one country, but also about the additional separation of powers between the EU and member states, or as Michael discussed, between the federal and state governments in the US. I would say that we actually encounter separation of powers issues in almost all of our cases in some form. And one interesting example that might be known to several of you in the UK, for example, around our UK clean air litigation, arose because of in that case, the UK Supreme Court actually found that despite the fact that the government was in breach, it couldn't do anything about that. It was exclusively within the competence of the EU Commission to enforce the EU law. They ended up referring that question to the CJEU, which of course agreed with ClientEarth, confirmed our standing to challenge the government's inaction under the directive, and then actually found that the national judiciary was empowered under EU law to provide an effective remedy against the national government. So kind of a very different type of separation of powers, but along similar lines to what you would have within a national court or a domestic setting. And we had a very similar case following that in Germany with our partners DUH, where we had a Munich environment minister who was openly defying an order of a German court to implement measures to combat urban air pollution. And there was very little incentive for him to comply with that, because the court under German law had very minimal ability to impose sanctions. It was a de minimis amount, and it went directly from the environment minister to the municipal government. So they weren't super upset about that 100 euros a day. So actually there again, we worked with our partners DOH to enforce, seeking increased penalties and even asking for imprisonment of the environment minister for contempt of court. And again, the court found that it didn't believe it had these powers under German law, but it referred the matter to the CJEU. And the CJEU similarly in that case confirmed that domestic national courts have to have the broad level of discretion to implement effective remedies against the national government for non-compliance with EU law. And so that was, the CJEU of course cautioned that imprisonment might run into other problems, but it did confirm that the court's domestic powers are necessarily broadened to enable them to provide effective enforcement of EU law. So those are just two examples. There are many more, and very different interesting issues we run into in Central and Eastern Europe and elsewhere, as well as in the UK. But I'll pause there in the interest of time and let you talk to some other people in other jurisdictions.
That's very gracious of you. Thank you, Amy, because we're a bit tight. Anyway, look, let's move. Let's go to Viviana Krsticevic now, who can speak for the Center for Justice and International Law, where she's the executive director, and take her particular view on separation of powers from her part of the world. Viviana.
Well, despite my surname, I'm from Argentina, and I live in.
I'm so sorry, Viviana.
And I work in Latin America primarily as a human rights defender and as an attorney. And we've seen the doctrine of separation of powers playing a role in parts of the litigation that we do, but we do not believe that is the primary obstacle or the main obstacle in adjudicating climate justice cases in Latin America. And that's not because there's a tradition at the local court level, at the higher courts, and even in our regional human rights court to stand on a tradition of putting a check to the strong powers of the executive. And also we have many general provisions in our constitutions that open our legal systems to international human rights law, and in turn, international human rights law and many of the constitutions in our region recognize the right to a healthy environment. And that has been critical. The Protocol of San Salvador, the recently adopted Treaty of Escazú, the Inter-American Democratic Charter talk about the right to a healthy environment, and even the Inter-American Court has done some work in case law and in some of their advisory opinions in developing the right to a healthy environment and some of the procedural and substantive rights that are critical to the litigation of climate cases. And however, and here I go to Elizabeth's point, even when the doctrine itself is not a major obstacle, I have to say that in many contexts, there is a lax oversight of the regulatory and enforcement duties of states. And the courts have not been forceful enough in that area. And also there are questions of these policies, national policies and beliefs that extractivism and the role of extractive industries are key, and sometimes some level of aggressive agricultural businesses are key to our development. And that has actually created some de facto refrain from the judiciary. So I would leave it there.
Thank you very much, Viviana. Lots of interesting parallels and questions about the relationship between the existence of an enforceable doctrine and the reality of the enforcement in various parts of the world. We'll no doubt, if we have time, to come back to. Let me move now to Irum Ahsan, the advisor at the Office of Compliance Review Panel at the Asian Development Bank. Irum, over to you, please.
Hi, thanks, James, and thank you for inviting me, the organizers. I bring in the Asia and the Pacific perspective because that's where Asian Development Bank works in, and me and my team and the Law and Policy Reform Program of the Asian Development Bank has been working over the last decade, more than a decade, with Asian and Pacific judges on environment, climate change, and sustainable development issues. So hence we bring in this perspective, and recently we captured all of this work into a 4-series report called Climate Change Coming Soon to a Court Near You, which is kind of an Asian and Pacific perspective, and Sabin very kindly partnered with us in giving the global perspective so that it can become one-stop shop for judges and lawyers. But the crux of this work is that often we were initially international organizations as well as many countries were surprised at why is Asian Development Bank working with the judges, because more obvious partners for us is executive, like ministries of environment and all. So why judges? Even within the bank, when we asked for funding to work with the judges, they asked us why judges? And we had to tell them that Asia and Pacific is a different animal altogether, because in this region, institutions are very weak, unfortunately. Regulatory bodies have no powers. So where are we leading? So people do not see courts as a last resort. They see, in fact, courts as a first resort because they get constitutional rights implemented in no time. And of course, it depends if judges can handle those cases. Now, what we learned in Asia and Pacific is that judges, when they were becoming lawyers, they don't even study environmental law. So that's the knowledge that they come with. And then they're handling these huge cases with huge problems and issues. So that's why we realized that this is the space we need to work in, because judiciaries are very empowered and because they are not seen as the last resorts. They become, I think, as Lavanya rightly said, I mean, they become literally the first best choice for Asian Pacific jurisdictions. So hence we decided to work. Then the second criticism when we started working came in that, isn't that encroachment on executive power? Because you're empowering judiciaries, you're encouraging litigation. And so when we wrote these 4-series report, actually, these were the areas we really looked into so that we can answer these issues. And we realized that it's not. And recently, actually, the argument that we have been placing as in support of judiciary and why we are working to build capacity of the judiciary is that another very activist environmental lawyer, now he's a judge in the Supreme Court of one of the countries, recently gave a decision in which he differentiates between judicial activism, judicial overreach, and judicial review. So this was something I remember when international community of environmental judges, they saw this decision coming out of Pakistan. He's the same judge who authored Asghar case. So all of the judges said we were waiting for this kind, because everybody is criticized of being judicially active. So thank you for giving. So in that, he very beautifully differentiates between these. He says that judicial outreach is when you actually encroach upon executive legislature powers by doing something which is not anchored on the law or on constitution. For instance, a beautiful example that he gives is that, yes, law says the driver of a motorcycle has to wear a helmet. Now, probably judicial activism could be that even the passenger who's sitting behind should wear helmet, right? But if you say that a petrol pump cannot give a petrol to a motorcyclist who's not wearing helmet, will be judicial outreach, because it has so that's something he says is outreach. But in activism or judicial restraint, he says is when a judge decides to progressively interpret law and constitution, or decides to hold the status quo, which will be judicial restraint. So he says, for instance, for human rights purposes, if constitutional provisions are progressively or liberally interpreted, that's not judicial activism. It's actually enforcement of fundamental rights enshrined in the Constitution. So, that beautifully answers why we need to really educate judges and build their capacity. And then in Asia Pacific region, another, which is now very common, strategic litigation is taking place. And through that strategic litigation, a lot of rights are being established, international treaties are being implemented, or they find root. And an example, a lot of people quoted Assalagari. There are beautiful decisions coming out of India. These are in Asian region, Pakistan and India are the most active two countries from where we find a lot of litigation and good examples. But there is also Nepal and Sri Lanka and Bangladesh. So in Nepal, few judges have done excellent interpretations of Paris Agreement. Interpretation of the Constitution to include Paris Agreement. They have actually addressed vulnerabilities. In one of the cases in India, they said that women have to walk extra miles to collect water because of this particular case. It was a Bangladeshi case, a shrimp farming case. And they brought in disproportionate impacts of climate change on women. So, I do not call it judicial activism. This is exactly the enforcement of constitutional rights by these judges. I happened to meet this judge just this morning, and I said, well, you have given me my 2 points to talk about tonight. I am working in Pakistan these days. So I met a few environmental judges. While I was here, I thought, let's meet them and see what's happening. This judge just had one simple case. I think it was, in the end, I don't even know what the case was because it's not a reported judgment yet. It's still continuous mandamus. It's an open case. So I don't know what was the initial point that petitioner brought before the court. I think it was against use of plastic bags. Under that case, like Asfar Lafari, this judge actually constituted, it's called Judicial Water and Environmental Commission. Now, this commission, we have seen a lot of commissions coming out of judiciaries in Asia, but those commissions were like a technical support for the judges. Judges said, we are not technically very savvy, so we need technical scientific support. So they used to constitute environmental commissions of experts from private sector, from science, technology. This commission, he said, is not the experts commission. It is like an agent of the court. He said that I will keep this as before. This is a continuous mandamus. I am going to keep this petition open, and I make sure that whatever decision I give is implemented. Because the EPA is not working, because government is doing this inaction, I need to make sure that in my lifespan, my decisions and my actions are implemented. So this commission is basically implementing court's decision. So he says, he used the words agent of the court. And my goodness, I did not even know the city of Lahore, where I live in, so much has already been done. I would not have been impressed if it was all talk. But these actions have already been done. In one case, he has opened up water channels. He has constructed recycling plants in shrines, religious shrines, where we do ablution and water is wasted. So he's collecting water from there. He's built water harvesting treatment plants in parks. He has closed down brick kilns and replaced them with zigzag new technology. Name it, and he has already done. The smog issues, people living in Delhi and Lahore, they know what happens in winters. There's a toxic air in these cities. So this one judge, because he's enlightened, because he's educated, because he's trained, he was also the judge who's never studied environmental law. Look the changes he's brought under one petition, and I will not call it judicial activism. I will call it simply helping executive, because executive is not taking any action. So that is why we decided to work with these judges, and that is why a lot of litigation is coming from Asia Pacific, which is now being replicated in the global West. So that's the power of Asian and Pacific judges. Thank you.
Wow, there's some serious creativity going on there in those courts. We know one or two judges around the world that might be a bit envious of about that capacity. My wife's a judge. I might have a discussion with her about whether she'd like those powers. But now we're going to turn to Professor Ramanathan, who is the Edward Frieman Endowed Presidential Chair in Climate Sustainability at the wonderful Scripps Institute of Oceanography at the University of California, San Diego. And Ram, I know you want particularly to address this issue of the relationship between science, separation of powers, and the role of the law, and a concern that you have, like many of us, a law addressing fundamental inequalities in the way the burden of climate change falls. So over to you.
Thank you, James. Can you hear me?
Very well, thank you.
Very good. I'm happy to be joining this panel as the only climate scientist. I published my first paper in 1975. It was made it to the front page of New York Times, so I expected drastic climate actions right away. And I've been waiting 46 years. So I must say, I'm delighted to see this interest in the courts and tribunals to take up this issue. So what's happening with climate change? It is accelerating just since the last 5 to 10 years, and particularly the link between the warming, global warming, and extremes. These extremes include heat waves, fires, droughts, floods, so on and so forth. And so what do I mean by acceleration? In about 2015 is when the planet crossed the warming of 1 degree. And just that 1 degree warming has caused all these damages we are experiencing. We are now predicting in another 9 years, by 2030, there is at least a 50% probability the warming will amplify by 50% from 1 to 1.5 degrees. I fully expect, I've gone on record suggesting that when we cross that 1.5 degree warming in 9 years from now, climate change will move into all our living rooms. Every one of us either will personally experience these extremes or would know someone who has experienced this. So the issue to me is not overcoming the separation of powers. I think it's going to overwhelm all our social systems in society, governments, legal institutions, legislature, etc. So everyone is going to need enormous help. So I urge all the judges, the legal experts here, to be prepared, to be overwhelmed. Please sharpen your skills. We need you. One thing I want to report is there was a study which was published last week, a team of experts, legal experts from Oxford and Harvard, and they said the evidence submitted and referenced in current litigation actions lags far behind state-of-the-art climate science. Colleagues, I want to tell you, just don't rely on IPCC. The science is advancing fast. And I must say the attribution science, that attributing particular events you are experiencing locally to the global warming, has improved tremendously to advanced litigation cases. Again, I want to caution you, I don't think any one of us can claim global warming is causing these extremes. But what we can prove is that global warming is acting as an amplifier, okay? So that's, and let me just, I know the time is short. I want to address an issue which has been bothering me for at least the last decade or so, since I started working with the Vatican on these issues, is that 50%, more than 50% of the global warming emissions are from the wealthiest 1 billion people in the planet. There are 3 billion in every country. America has about 80 million amongst this 3 billion, living largely in rural areas or in slums, who have very little to do with this global warming. I have estimated their contribution. It's about 5%. But we all know when we cross that 1.5 degree warming, in 9 years, I want to keep drilling that 9 years into you, that there are going to be major cliffs which society has to jump down. It's those 3 billion who are going to go ahead of us down, although they had very little to do with this. I don't see there are a lot of lip service done. What we need is enormous amount of funds to build resilience in this society. First, public health and mental health. There was a study done by a neuroscientist at University of California, San Diego, Dr. Jyoti Mishra. She has shown that in the famous campfire in California, incidents of mental health like depression, post-traumatic syndrome, and other, all intensified by a factor of 2. So I think our public health system is going to be overwhelmed. And the second thing, this is not my work I want to report on, is that experts are, are expecting, as we shoot past that 1.5 degrees, the migrant issue, climate refugees, are going to be in millions. And who's going to protect them? Thank you, James.
Well, Ram, that's fantastic. And it serves to emphasize a point that I believe we will keep returning to over the 2 days. This issue of fairness and justice and inequality, the law exists to deal with. Insofar as the law represents an ideal, it allows the weak to use the law against the strong. In fact, law has that as an essential element. It translates, it transforms natural power into legal power. That's why we can bring actions against our political leaders or large corporations. That's the whole point. It's the essence of a legal order, is that it transforms natural power into legal power. Now, we don't have a lot of time left. We have about 10 minutes, and we have a very good presentation coming up, although it is recorded, by Louisa Marie Neubauer, who's a youth climate activist, and we want to hear that. So in this short period of time, could I just ask, having listened to everybody else and these very good interventions from different parts of the world, could you just reflect on how much of the problem of the, if you like, the role of law in solving climate change is associated with separation of powers and the doctrines that relate to it, and how much, because of the separation of powers, there might be opportunity for the law to play a creative and constructive role. Having listened to you all, I can see quite a variety in response in various different jurisdictions. Even just to go back to you, Michael, briefly, if I may, your example of the Supreme Court now structurally divided 6-3 along inverted commas conservative lines. If their doctrine of non-delegation would open up the possibility that legislation that was very specific could be passed in the Senate, big question right now, but not impossible, then presumably that doctrine would make it easier to enforce that legislation in a conservative court like that, despite their views on the role of, say, the EPA. So I just want to go back around very briefly as we cover the whole, all of you. What are your reflections, having listened to the others, on this notion of separation of powers? Are you persuaded that have you shifted your mind, or how do you respond? Let's start with you, Michael.
I think it's clear that the laws vary quite considerably from one country to another, and the different legal systems have profoundly different views on that. I think if we did have enough of a Democratic majority in the United States Congress, it could pass very powerful laws that could have an enormous impact. And I think that if the laws were well written and specific enough, they would make an enormous difference. We don't know what the next election will bring, but Congress clearly has the power, and the Congress has exercised that power in other areas, and it could exercise that power here. But it ultimately, the real power is at the voting booth, not in the courts. And if the voters elect the right kind of representatives to Congress and the White House, I think a great deal can be done.
Right. So I'll leave it open to any of you to contribute, but I thought because she was so gracious, I might come back to Amy, who was very careful with her time, to see what your point of view. And then I think just speak up, whoever would like to follow Amy, be ready.
Thanks, James. Yeah, I would have to agree that I think with the premise of your question, which is that, where there's a door that closes, a window opens. So it seems to me that in all of these cases, when we're struggling against separation of power issues one way or another way, it opens up other opportunities. I don't want to call them loopholes necessarily, but just other avenues and ways to maneuver. And of course, I think it's really important. I know we're talking about litigation, and I'm the director of litigation, so we all love our litigation, but it's really important to marry your litigation with a strong advocacy campaign that kind of acknowledges the interplay of these two tools and uses them together, which I think we're seeing more and more of the campaigns and cases are getting much more sophisticated in really using the litigation to directly pressure an advocacy opportunity or vice versa. And I think that's really something that we'll see more of, and that's really important to, finding the window when the door closes.
No doubt, if you want to make the most of your litigation advocacy, you have to have it combined with some other form of advocacy that accelerates either the political process or some other change in society that can validate, endorse, and amplify your particular case. Who's ready to go next? I'm tempted. I'll call out someone. Is Viviana, you ready to go? Yeah, go ahead.
I think I'm ready to go in underscoring that it is clear by the presentations that we had that different jurisdictions might call for a different plan of action. But in listening to the presentations that were done before in terms of the overall strategy, there's also, to me, a clear perception that there are significant gaps in how we envision the overall litigation of climate justice issues, and that the doctrine of separation of powers can be one key aspect that has to play in some jurisdictions, and it has to also be more analyzed with more detail to identify if we're talking about issues of standing, causality, of the extent of rights or the extent of remedies that can be foreseen by the judiciary. I would call for us in looking at this issue to be mindful of those distinctions and to be much more purposeful in thinking through what would be a thoughtful, fair, effective strategy for advancing these issues.
Got it. Very clear. Who else is ready to step up?
If,
Yeah.
James,
Yeah, go.
that's all right.
Go ahead. Oh, I can't be here. Go ahead. Can you hear?
I can go next, James. If
Okay, perfect.
Okay. So to my mind, this separation of powers, yes, it's important. It's there for a reason. It needs to stay. But in cases of climate change, in cases of, especially in this pandemic era, it's an imminent global crisis. And in global crisis situation, sometimes the lines of separation of power
He's gone. Okay, we lost you, Irum. Can you come in, just quickly conclude, because we lost you for a while. No, she's not hearing us. Okay, we might just, who else is ready to step in the, Elizabeth, are you ready? Or you don't have to speak if you don't want to, but if you're ready, go ahead.
All right. Yeah, I would say there have been a lot of learning and interlinkages from everyone, but one thing that's really standing out is the fact that we all agree that courts have a huge role to play in taking legal action on those who breach our human rights and our rights to a clean and healthy environment. And of course, as a young activist, it's good to highlight that young activists get arrested while demanding governments to take action on climate change, which is definitely unjust. Yet peaceful protest is a right that needs to be protected by the courts. So that's why activists are increasingly taking the climate fight to the courts. And as judges, you might as well have the last word on the climate crisis. Please make it count for all generations to come, because we are counting on you. Thank you.
Okay, well, I'm sorry we lost you briefly there, but we were very grateful for her comments earlier. And I'm just going to close this off now so that we have the presentation from another climate activist, Louisa Marie, just by saying the obvious thing. Thank you so much for all of your contributions. This is obviously a critical issue to get separation of powers right. I still think there's a contest that we need to play out a bit more, depending very much on the political culture and the mechanics and the practical reality of using the law in various jurisdictions. It's not a straightforward question as to where separation of powers lead you and where it's a problem and where it might be an advantage, depending on whether you have, like Irum's friend in Pakistan, some immense creativity and drive and scope to do things that maybe other judges couldn't do. But I know from the many conversations with my own wife as a judge that these tensions are felt very personally by judges too, and that we need to understand their situation and to understand that they feel tremendous pressure to abide by the doctrine of their place, the practice of their profession, their peers and what they think, and the independence of the judiciary, as Elizabeth so clearly stated in her presentation, is absolutely vital. Otherwise, the rule of law can't operate. And if the rule of law doesn't operate, then you can't take on abuse of power. Then you're not able to use the law to do the distribution of rights and duties that we so obviously need. And we will not be able to use the law in the way that Ram suggested that we needed to do. So again, thank you so much for your contributions. We really appreciate them. There are questions that I've not been able to get to, but I'm going to go through them in the chat afterwards, and maybe we can pick them up overnight and refer to them tomorrow. Thank you for joining in. I'm sorry if I couldn't contribute all of your questions, but now I think to keep the time, we must shift to a presentation with a perfect title, We Need to Change the Rules. And this is Louisa Marie Neubauer, a youth climate activist from Germany.